There is a considerable difference between the basic legal concepts of doing personal injury evaluations versus doing criminal evaluations as a forensic psychologist. In criminal evaluations, the concern is with the perpetrator that has victimized someone, and your psychological evaluation has an impact on helping the court decide, the trier of fact decide what happens to that perpetrator. Whereas in a personal injury evaluation, the major concept is that of tort law, or the major guiding principles are in tort law. And tort law is an area that focuses upon civil wrongs. In fact, the word tort itself means civil wrongs. And here, the objective or the outcome of your evaluation is somewhat different than in a criminal evaluation. In a personal injury evaluation, you're trying to help the trier of fact, the court, decide what to do when a person has been wronged civilly. And the basic idea is that the court wants to restore that person that has been wronged to a condition prior to the alleged incident that led to some kind of injury. So the court tries to restore, make right, make whole in some way the individual that has legitimately had some type of a civil wrong done to them. And so you can see the direction of your psychological evaluation is quite different in tort cases, in personal injury cases versus in criminal cases. Black's Law Dictionary defines tort law as personal injury that includes a private or civil wrong or injury other than a breach of contract for which the court will provide a remedy in the form of an action for damages. And when you look at tort law, there are four basic elements that have to be there. And the psychologist needs to know these elements and respond in their evaluations and in their testimony to the court. The first thing that has to be there in any kind of tort case, in any kind of personal injury case, the first thing that has to be there is that there has to be a duty or obligation that is recognized between the person that is wronged, which we will call the plaintiff, and in the legal context they are called plaintiffs. There has to be a duty between the plaintiff and some individual or organization that has committed the wrong. And the organization or individual that has committed the wrong is called the defendant. And it can be a person, a corporation, or some kind of organization. But there has to be a duty there. There has to be an obligation that's recognized. For example, a corporation has an obligation to their employees. They have to protect their employees. They have to have a safe work environment for them. They can't be abusive to them. A psychologist, for example, has a duty. There is a duty or obligation to our clients. Again, to provide the best standard of care that we can to our clients. A psychiatrist likewise has a duty to their client. A physician has a duty to their patients. An OBGYN physician has a duty to their patient to provide the best available care that they can to their patient, and not to be negligent in their duty to their patient. So there has to be a recognized duty or obligation. That's the first element. The second element is that there has to be a dereliction of that duty, either through an act of omission or commission. So basically, if I have an obligation to, or a corporation has an obligation to a person, and doesn't do what's necessary to protect that person, their employee, for example, well, then that's a dereliction of duty. And something happens to that employee, that's a dereliction of duty. If a physician, for example, knows that a patient has a particular kind of a sickness, an illness, and doesn't respond appropriately to that within the normal standards of care of physicians, then again, that's a dereliction of duty. So there has to be a duty or obligation that's recognized. There has to be a dereliction of duty. And then thirdly, there has to be some damage or disability that becomes obvious and that the plaintiff, the person that's alleging this damage or disability, is putting forth as something that has caused them harm. So there has to be, again, a duty or obligation, a dereliction of duty, and there has to be some kind of damage or disability that results. And then finally there has to be what's called a proximate cause. And a proximate cause is a concept of law which basically means there has to be a connection, a causal connection between the alleged traumatic event or situation and the damage that the plaintiff is alleging. And a proximate cause is a cause that means that if that event or situation had not occurred, then the damage would not have occurred. Now, and we'll get to this in just a little bit, there can be a pre-existing condition, and the plaintiff can allege damages or harm if the pre-existing condition is made worse by whatever traumatic event that is alleged to be a proximate cause. So the four elements again are: there has to be a clear and specific duty owed between the plaintiff and the defendant. There has to be a dereliction of that duty. There has to be clear damages or disability that results. And then there has to be a proximate cause. For example, in the third element, if someone, and we'll look at a court case like that in a little while, but if a person is in a traumatic situation, but there's no demonstrable damage or harm or injury, then the person basically has no basis for an alleged personal injury claim. And we'll see some examples of that as we go along.